Check 6, 6. Check. Check 5. Check, check, check. Check, check, check. 5. Check. Check, check, check. Like 6, check, check.
They should hear that. And I think that that's the kind of thing that the Democrats on the committee can take in, maybe in ways that the ad laws conceptualisms don't necessarily sink in. Hope they'll do both, but I know that they're attentive to the regulatory.
The Subcommittee on Regulatory Reform, Commercial and Antitrust Law will come to order. Without objection, the Chair is authorized to declare a recess of the committee at any time. We welcome everyone to today's hearing on H.R. 4768, the Separation of Powers Restoration Act of 2016, and I now recognize myself for an opening statement. Today's hearing continues our discussion and inquiry into the 30-plus-year-old Chevron doctrine. Our prior hearing gave us an opportunity to examine Chevron and question whether or not it remains appropriate in light of the modern administrative state. Today, we turn to H.R. 4768, the Separation of Powers Restoration Act, a piece of legislation offered by my friend from Texas, Congressman Radcliffe. I'm proud to co-sponsor this legislation that would begin the process of reeling in administrative overreach. As Chief Justice John Roberts correctly described it 2 years ago in his dissent in City of Arlington versus FCC, the framers could hardly have envisioned today's vast and varied federal bureaucracy and the authority administrative agencies now hold over our economic, social, and political activities. My own experience as an industrial baker, prosecutor, and now legislator have exposed me to the myriad levels of hurdles and complete unknowns of the modern administrative state. Navigating this morass is a daunting task, if not impossible, challenges for employers and workers across the nation. Agencies, often too numerous to count, interject themselves into nearly every aspect of daily life. And to make matters worse, the bureaucrats writing regulation know how to shape their rules to satisfy Chevron and achieve their sought-after outcome. For regulated entities, especially small businesses, the deck is stacked against them from the start. But these citizens have sent us to Washington as representatives of their interest, hardship, and we hope success. It is a privilege we often take for granted and an honor that we can repay through thoughtful, clear, and concise lawmaking. The Chevron doctrine represents an abdication of the legislative responsibility. Over 30 years of Chevron deference, we have seen the gradual creep of executive agencies from administrators of the legislative process to becoming legislators themselves. Rather than executing the will of Congress, agencies now have the freedom to define the law as they see fit. This is not a system that respects the checks and balances that we have existed since the first days of our nation. Chevron and its progeny are a departure not only from the Constitution, but from the Administrative Procedure Act, Congress's original effort to bring order to the rulemaking process. Today's discussion on the Separation of Powers Restoration Act presents an opportunity to reassert the lawmaking authority of Congress. It embodies the tripartite vision of governance established by our founders. The unfortunate nature of the 21st century administrative state is its breadth and reach. As I said in March, while the Chevron doctrine may not be as glamorous or headline-worthy as other issues before Congress, its effect on the everyday lives of Americans cannot be understated. And its ability to fundamentally change the working of our government and undo the guards long put in place to prevent tyranny and abuse is profound. Our goal today is to examine the bill before us. Our hope is to craft a final bill that creates stability in the rulemaking process, removes the power to legislate that has slowly found its way into the rulemaking process, and return the judiciary to its proper role and power to say what the law is. We are fortunate to have a panel of witnesses with a wide range of expertise and experience on this issue. I look forward to their testimony and an engaging discussion of this important issue. I now recognize the ranking member of the committee, Mr. Johnson from Georgia.
Thank you, Mr. Chairman. Judicial review of final agency action is a hallmark of administrative law and is critical to ensuring that agency action does not harm or adversely affect the public. But as the Supreme Court held in Chevron versus Natural Resources Defense Council, reviewing courts may only invalidate an agency action when it violates a constitutional provision or when an agency exceeds its statutory authority as clearly expressed by Congress. For the past 30 years, this seminal decision has required deference to the substantive expertise and political accountability of federal agencies. Judicial deference is born from principles of political accountability and separation of powers. As the court explained in Chevron, quote, federal judges who have no constituency have a duty to respect legitimate policy choices made by those who do. The responsibilities for assessing the wisdom of such policy choices and resolving the struggle between competing views of the public interest are not judicial ones. Our Constitution vests such responsibilities in the political branches, end quote. H.R. 4768, the Separation of Powers Restoration Act of 2016, so-called, would eliminate this long-standing tradition of judicial deference to agencies' interpretation of statutes and rules by requiring courts to review all agency interpretations of statutes and rules on a de novo basis. This misguided legislation is not the majority's first attempt to gum up the rulemaking process through enhanced judicial review. Since the 112th Congress, a number of deregulatory bills we have considered, such as H.R. 185, the Regulatory Accountability Act, would require generalist courts to supplant the expertise and political accountability of agencies in rulemaking process with their own judgments. Compare this approach with other deregulatory bills passed this Congress that would greatly diminish judicial review over deregulatory actions by dramatically shortening the statute of limitations for judicial review, sometimes to just 45 days. In other words, the majority wants to have it both ways. When it benefits corporate interests, Republican legislation heightens scrutiny of agency rulemaking, threatening to impose years of delay and untold cost on taxpayers. When it benefits the public or our environment, Republican legislation slams the courthouse doors shut through sweeping restrictions on the court's ability to protect public health or the environment. These proposals, which are transparently the design of the donor class to minimize their exposure to legal accountability, are just another example of how some not only want the fox to guard the chicken coop, they want to give the fox the responsibility of keeping the chicken coop clean as well. H.R. 4768 is more of the same. In closing, I look forward to testimony from our esteemed panel, and I thank the witnesses for their testimony, and with that, I yield back.
The chair now recognizes the chairman of the full committee, Mr. Bob Goodlatte of Virginia, for his opening statement.
Thank you, Mr. Chairman. The modern federal administrative state is an institution unforeseen by the framers of our Constitution and rapidly mushrooming out of control. The Separation of Powers Restoration Act of 2016 takes square aim at one of the biggest roots of this problem, the Chevron doctrine, under which federal courts regularly defer to regulatory agencies' self-serving interpretations of the statutes they administer. Similarly, the bill takes on the related Auer doctrine, under which courts defer to agencies' interpretations of their own regulations. In perhaps the most famous of the Supreme Court early decisions, Marbury versus Madison, Chief Justice Marshall declared for a unanimous court that it is emphatically the province and duty of the judicial department to say what the law is. Since the Chevron doctrine allows judges to evade interpreting the law and instead to defer to agencies' interpretations, one must ask, is Chevron faithful to Marbury and the separation of powers? In the Administrative Procedure Act of 1946, often called the Constitution of Administrative Law, Congress provided for judicial review of agency action in terms that were plain and direct. It stated that the reviewing court shall decide all relevant questions of law and interpret constitutional and statutory provisions. That standard is consistent with Marbury and the separation of powers. But since Chevron allows judges to escape interpreting statutory provisions themselves, one must ask, is Chevron unfaithful not only to Marbury and the separation of powers, but also to the Administrative Procedure Act? These are not just academic questions. They are fundamental questions that go to the heart of how our government works and whether the American people can still control it. The genius of the Constitution was that by separating the legislative, executive, and judicial powers into three distinct branches, the ambitions of each branch would check and balance the ambitions of the others. As long as the separation is kept strong, that system of checks and balances preserves liberty, as the framers intended. But judicial deference under Chevron weakens the separation of powers, threatening liberty. It bleeds out the judicial branch power to say what the law is, transfusing that power into the executive branch. And it tempts Congress to let the hardest work of legislating bleed out of Congress and into the executive branch, since Congress knows judges will defer to agency interpretations of ambiguities and gaps in statutes Congress did not truly finish. This leads us down the dangerous slope James Madison warned against in Federalist 47. The accumulation of all powers, legislative, executive, and judiciary, in the same hands, that may justly be pronounced the very definition of tyranny. This is what Americans across our nation feel in their bones to be dangerous when they fear a federal regulatory bureaucracy growing beyond limits, spinning out of control. They fear a government emboldened to burst our system of checks and balances, trespass without limit on their liberty, and threaten their way of life, all at the whim of swarms of administrators in a far-off capital. They fear an all-reaching, unaccountable bureaucracy that threatens our system of self-government by and with the consent of the people. The Separation of Powers Restoration Act of 2016 is timely, bold legislation directed straight at this problem. In one fell swoop, it restores the separation of powers by legislatively overturning the Chevron doctrine and the related Auer doctrine. This is reform that we must make reality for the good of the people. I look forward to the testimony of our witnesses as we consider this crucial bill, and I am particularly interested in hearing their views on whether more terms should be added to the bill to further guide the judiciary on the appropriate interpretation of statutes and regulations as it resumes fully the province and duty of the Judicial Department to say what the law is. And I want to especially thank my colleague from Texas, Mr. Ratcliffe, for his leadership on this issue and for introducing this fine legislation, and to Chairman Marino for his work chairing this subcommittee and addressing this important subject. Mr. Chairman, I yield back.
Thank you. Without objection, other members' opening statement will be made part of the record. I will begin by swearing in our witnesses before introducing them, so would you please stand and raise your right hand? Do you swear that the testimony you are about to give before this committee is the truth, the whole truth, and nothing but the truth, so help you God? Let the record reflect that the witnesses have answered in the affirmative. Please be seated. Thank you. I'm going to read each of the witnesses, each of your introductions. I'll get through all 6 of you, and then we'll get back to you making your opening statements as well. Okay. John Duffy is the Samuel H. McCoy Professor of Law at the University of Virginia Law School. Prior to joining UVA's law school, Professor Duffy taught at the George Washington, Benjamin N. Cardozo, and William and Mary Schools of Law. He has also taught at the University of Chicago Law School. Professor Duffy served as an attorney advisor in the Department of Justice's Office of Legal Counsel and practiced law with the firm of Covington and Burling. Professor Duffy is widely published and the co-author of a casebook on patent law. Professor Duffy earned his bachelor's degree in physics from Harvard University and his law degree from the University of Chicago, where he served as articles editor of the Law Review. Professor Duffy clerked for Judge Stephen Williams on the U.S. Court of Appeals for the D.C. Circuit and for the late U.S. Supreme Court Justice Antonin Scalia. Welcome, Professor. Jack Bierman is the Harry Elwood Warren Scholar at the Boston University School of Law. He previously taught at various universities, including Harvard, DePaul, the Interdisciplinary Center in Herzliya, Israel, and the China University of Political Science and Law. Professor Bierman is published widely in top-ranked journals. He has authored and co-authored 4 books on administrative law, including a widely used casebook and the Emmanuel Law Outline on the subject. Professor Bierman earned his bachelor's degree in political science and philosophy from the University of Wisconsin-Madison. He holds a law degree from the University of Chicago Law School, where he was elected Order of the Coif and served as editor of the Law Review. Welcome, Professor. Jeffrey Clark is a partner at the law firm of Kirkland & Ellis, LLP, and specializes in complex trial and appellate litigation. Mr. Clark has been with the firm since 1996, with the exception of 2001 to 2005, when he served as the Deputy Assistant Attorney General for the Environment and Natural Resources Division of the Justice Department. During his appointment at Justice, Mr. Clark supervised the division's appellate section, 50 lawyers and staff, and Indian Resources section, 25 lawyers and staff. He has argued and won the noted Massachusetts versus EPA case in the D.C. Circuit and is rated AV Preeminent 5.0 out of 5 by the Martindale-Hubbell, the highest level of professional excellence. Prior to joining Kirkland & Ellis, Mr. Clark was a law clerk for Judge Danny J. Boggs of the United States Court of Appeals for the Sixth Circuit. He has written and appeared extensively in public on topics in energy efficiency, clean air, and water law, administrative law, and constitutional law. Mr. Clark is an elected member of the Governing Council of the ABA Administrative Law Section and is currently serving as co-chair of the ABA Section of Administrative Law and Regulatory Practices Committee on Environmental and Natural Resources Regulation. Mr. Clark graduated with an AB in Economics and Russian Soviet History, cum laude, from Harvard University, an MA in Urban Affairs and Public Policy, summa cum laude, from the University of Delaware, and a JD magna cum laude from Georgetown University Law School. Welcome, sir. Mr. Walk is a senior attorney and clean air director for Natural Resources Defense Council in Washington, D.C. He is responsible for NRDC's National Clean Air Advocacy Program before Congress, the courts, and the U.S. Environmental Protection Agency. Prior to joining NRDC, Mr. Walk worked for the EPA in the Air and Radiation Law Office of the Office of General Counsel. At the EPA, he worked on permitting air toxics, monitoring, and enforcement issues under the Clean Air Act. Prior to working for EPA, Mr. Walk was an associate at Beveridge and Diamond in Washington, D.C. Mr. Walk graduated from Duke University with a BA in English and earned his JD from Harvard Law School. Thank you, Mr. Walk, for being here. Ronald Levin is the William R. Orthwein Distinguished Professor of Law at Washington University in St. Louis. Mr. Levin is the co-author of a casebook, State and Federal Administrative Law. Professor Levin has chaired the section of Administrative Law and Regulatory Practice of the American Bar Association, a group of which he is still an active member. He served as the ABA's advisor to the drafting committee to revise the Model State Administrative Procedures Act. Professor Levin also served as a public member of the Administrative Conference of the United States and the chair of its Judicial Review Committee. Professor Levin clerked for the Honorable John C. Godbold of the U.S. Court of Appeals for the Fifth Circuit and practiced with the Washington, D.C. firm of Sutherland, Asbill, and Brennan. Mr. Levin received his BA from Yale and his JD from the University of Chicago. Welcome, Mr. Levin. Adam White is a fellow at the Hoover Institution and the adjunct professor at the Antonin Scalia Law School at George Mason University. Prior to joining Hoover, he was an adjunct fellow at the Manhattan Institute. Mr. White practiced law with Baker Botts, working on various constitutional and regulatory matters, including energy infrastructure regulation. He also practiced law with Boyd and Gray and Associates, where he wrote briefs on constitutional and regulatory issues in the Supreme Court and various other federal courts. He continues to be of counsel to the firm in 3 pending cases involving the Consumer Financial Protection Bureau and the Federal Communications Commission. Mr. White writes on the courts and the administrative state for such publications as the Weekly Standard, the Wall Street Journal, Commentary, the Harvard Journal of Law and Public Policy, and SCOTUS blog. In 2015, he was appointed to the Leadership Council of the American Bar Association's section of Administrative Law and Regulatory Practice. He co-chairs the section's Judicial Review Committee and co-directs its Supreme Court series. Mr. White received his bachelor's degree in economics from the University of Iowa College of Business and his law degree from Harvard Law School, where he graduated cum laude. He clerked for Judge David B. Centel of the United States Court of Appeals for the Third Circuit. Welcome, sir. Each of the witnesses' written statements will be entered into the record in its entirety. I ask that each witness summarize his or her testimony in 5 minutes or less. To help you stay within that time, there is a timing light in front of you, and I don't know the colors because I'm colorblind. But what I will do is, as it gets down to the last color, which I'm told is the red light, I will just diplomatically pick up my little gavel here and let you know that would you please finish as soon as possible. Professor Duffy, you're on.
Okay. Thank you. Chairman Marino, Chairman Goodlatte, Ranking Member Johnson, and the distinguished members of the subcommittee. Thank you for inviting me to testify before you today. At the outset, I'd like to compliment the subcommittee for devoting time and attention to this matter and to this important piece of legislation, H.R. 4768, the Separation of Powers Restoration Act of 2016. The proposed legislation would be a welcome path out of the ever-growing morass of complex case law that these doctrines have generated over the past several decades. Importantly, the proposed legislation is admirable in its elegance and brevity, filling up less than a page of legislative text and adding a mere 2 words, de novo, plus some accompanying stylistic changes to the first sentence of Section 706 of the APA. This is a highly desirable approach to supplanting the Chevron doctrine and other judge-made doctrines of deference with a clear, easily understood, and theoretically sound principle to govern judicial review of all legal issues arising in administrative cases. My written statement and prior testimony sets forth in detail why I believe the proposed legislation is not really changing the APA, but is instead confirming the statute's original meaning. I'll mention one point in particular right now, which is that so strong are the statutory arguments in favor of de novo review, a de novo standard of review for legal questions from the original APA, that when federal courts of appeals have focused on the relevant statutory language, they have interpreted the APA as requiring de novo review of statutory interpretations even in the years after the Supreme Court decision in Chevron. One of the most important benefits of the proposed legislation is that it would eliminate the uncertainties and needless complexities of current decisional law. The Chevron doctrine as it exists today, and indeed the entire set of judge-made doctrines requiring deference to agency legal positions, is riddled with complexities and exceptions. Indeed, so pervasive are the exceptions that it would be wrong to assert that the proposed legislation would overrule or overturn the Chevron doctrine or other doctrines requiring judicial deference on legal issues. It is far more accurate to say the legislation would get rid of what's left of these doctrines. And as discussed below, as I've discussed in my written statement, what's left is not so much in many areas. Chevron and other doctrines requiring judicial deference on legal issues have come under increasing intellectual scrutiny over the past 2 decades, and because of the inherent theoretical weaknesses of the doctrines, the Supreme Court has made exceptions to them. As a result, the doctrines are both weakened and unpredictable. Just last year, the Supreme Court in King v. Burwell held that Chevron deference is inapplicable to any issue of deep economic and political significance that is central to a statutory scheme. King's exception to Chevron, which might be called a too big to defer exception, creates a major limitation on Chevron and also increases the opportunity for more litigation about whether Chevron should apply at all in any particular case, making the doctrine less valuable for agencies and more burdensome on all litigants. Another example about the complexities of this doctrine comes from the patent system, an area of administrative regulation in which I teach and write. Under consistent lower court precedent and Supreme Court practice, the Patent Office gets no deference in its interpretation of the substantive provisions of the Patent Act. But why? Under the reasoning of Chevron, which stresses the need for deference to expert, politically accountable agencies, the Patent Office would seem to be a leading candidate to receive deference. There are, of course, doctrinal reasons for the absence of deference in this area, but those doctrinal reasons merely underscore the complexity and incoherence of the case law spawned by Chevron. Though the proposed legislation would clearly end judicial deference to agency legal positions, it would not foreclose several unobjectionable judicial practices detailed in my written statement that are sometimes confused with deference. I will not detail those doctrines in my oral statement, but just say that those additional principles do not need to be codified in this proposed legislation, and I think the legislation as it exists now is an admirable and elegant vehicle. In closing, I once again commend the subcommittee for devoting time to this important matter and for devising an elegant way to restore the traditional role of federal courts to say what the law is. Thank you for your time and attention to these issues, and thank you for the invitation to speak to the subcommittee.
Thank you. Professor Bierman.
Thank you very much, Chairman Marino and Ranking Member Johnson and distinguished members of the subcommittee. It's truly heartwarming as an administrative law professor to see the committee spending such dedicated time and attention to this important issue that many of us have been working on for years. And I'm a Chevron skeptic, as the material included with my written submission reveals, and the language of H.R. 4768 would certainly be a complete reversal of Chevron and related doctrines. But while I share the view that the Chevron doctrine has gone too far and has become too confusing, the long history of judicial deference to agency legal decisions may point in favor of a less complete rejection of deference. Long before Chevron, it was generally understood that reviewing courts should pay close attention to agency reasoning when reviewing agency legal decisions, especially agency construction of the Agencies Enabling Act, in order to ensure that agencies remained within their delegation from Congress. What was extreme about Chevron was its assumption that statutory silence or ambiguity virtually always indicates Congress's intent to delegate interpretive authority to the administering agencies, Even if this assumption was erroneous, that does not mean that Congress does not sometimes delegate interpretive authority to an agency. In highly technical or sensitive areas in which Congress expects agencies to apply expertise, ambiguity might be an indication that Congress would want a reviewing court to be highly attentive to the agency's views. For example, when Congress delegated authority to the Federal Communications Commission to award broadcast licenses in the public interest, convenience, and necessity, Congress certainly intended for the agency to be primarily responsible for determining the meaning of those general terms. It would be a fundamental shift if H.R. 4768 were understood to forbid reviewing courts from deferring to agency determinations under that or similar statutory language. It has also been suggested that H.R. 4768 would have the salutary effect of introducing strict construction of delegations of authority to agencies, and that this would be positive. There are reasons, however, to be cautious on both of these scores. First, merely instituting de novo review of agency interpretations of statutes would not necessarily mean that such delegations would be construed narrowly. There are many traditional methods of statutory construction that point toward broad constructions of statutes, including delegations of authority to agencies. Second, although there are circumstances in which, as a policy matter, it is appropriate to read delegations of authority narrowly, sometimes Congress intends agencies to have broad authority to address the social problems within its jurisdiction. For example, narrowly construing agency delegations regarding communicable diseases or chemical contamination could have serious negative social effects. Before Chevron, traditional legal doctrine was by and large successful at distinguishing those situations in which broad interpretation of agency authority is more appropriate than narrow interpretation. Now, also, while I share Chief Justice Roberts' concern that agencies should not have free rein to determine their own jurisdiction, I'm afraid that it would be virtually impossible to craft statutory language that would distinguish jurisdictional from non-jurisdictional matters of statutory interpretation. So although I agree that H.R. 4768 is a laudable effort to dispel some of the negative consequences and confusion caused by the Chevron doctrine, I'm afraid that it would disable reviewing courts from taking into account the views of an administering agency on questions of statutory interpretation that would aid in advancing Congress's intent. So in my prior testimony, I suggested language under which Congress could react to all of the problems of Chevron deference without totally ruling out judicial deference to agency views. My suggestion would be, and I'll repeat it here, to add language to APA 706 as follows. Unless expressly required otherwise by statute, the reviewing court shall decide all questions of law de novo with due regard for the views of the agency administering the statute and any other agency involved in the decision-making process. Under this standard, the courts would apply the pre-APA Skidmore factors for determining how much to defer to agency interpretations, with flexibility to shape deference to meet modern concerns. Now, in my view, Chevron includes a sensible set of criteria for determining whether an agency interpretation is worthy of deference. In fact, the term deference may be a misnomer in this context. When Congress has delegated to an agency the power to administer a statute, and the agency has thoroughly considered a problem and provided persuasive, valid reasoning for its consistent view of the meaning of a statutory term, a reviewing court is likely to be convinced that the agency has made a correct decision, or at least a decision that is as likely to be correct as any contrary view advanced by the challengers on judicial review. So this reform, in my view, would restore to Congress the ultimate decision to determine how much deference there should be to agency legal decisions. And that's, of course, where such authority belongs. Thank you.
Thank you. Mr. Clark.
Thank you, Chairman Marino, Ranking Member Johnson, and distinguished members of the committee. And thank you. Oh, not on. There we go. Apologies. Thank you, Chairman Marino and Ranking Member Johnson and members of the committee for the opportunity to appear to you before you today to speak about the Separation of Powers Restoration Act of 2016. It's important that the title that you gave to this legislation, it indicates, where you're coming from, which I agree with. The separation of powers was an idea crystallized by the French thinker Montesquieu, and the founders knew a good idea when they saw one, and they embedded that idea into the structure of the Constitution and the difference between Articles 1, 2, and 3. The Chevron doctrine is entirely foreign to that classical conception of the Constitution. And I'd submit to you that there's zero evidence that the Congress that adopted the APA intended that to occur, intended such massive delegations, or intended to violate the separation of powers. And so I agree with Professor Duffy that what your act is doing is really restoring not just the separation of powers, but the original meaning of the APA, which in any event, even if there were ambiguity, is something that should be interpreted consistent with the Constitution or to avoid separation of powers concerns. The Chevron doctrine was never squared with the separation of powers, which makes it a defective decision on its own. And there's a lot of talk about Chevron being a case about expertise, but I'd submit to you that it's a very curious decision if that's what it is. It talks about expertise, but the test that it adopts has expertise nowhere to be found in it. The first step of the Chevron two-step is to look at the text of the statute, and the second step is, once again, to look at the text of the statute in terms of whether the agency has produced a reasonable construction of it. There is no portion of the Chevron test that has expertise built into it. So to defend the Chevron decision on expertise grounds, it seems to me, makes little sense, and is something that if it's being supported on that ground, it must be really supported because of results that it produces that those who favor those results like. In practice, and that's the perspective I can help to bring to you as being a practitioner, as being someone who served in the government, I can tell you that, and I set it out in my analysis, there was a particular compromise that animated Chevron. I think that the extent to which that compromise was ever really adhered to, it is broken down. The approach that I see, and I think, to be fair, I saw it not just in this administration, but I also saw it to some extent in the Bush administration. I saw approaching the statute with a particular idea in mind about what public policy in some area should be. And it didn't look first to the statute to see what instructions you, as members of Congress, had given the executive branch in a particular area. It instead looked at those constraints as inconveniences to be dealt with, essentially. And so very smart lawyers are sicked on the problem of how do we get this through the Chevron two-step? How do we secure deference? And from that perspective, Chevron, I think, has been a failed experiment as well. There's been a lot of talk about Skidmore deference as well, and I would caution you and disagree with those who say that Skidmore deference should be the substitute. Chevron should be wiped off the map, adopt Skidmore. My first question about Skidmore is, what work is it really doing? It's essentially urging courts to take seriously the reasons that agencies have given. That's, number one, what courts already do when they read briefs in the Supreme Court from the Solicitor General or from the Justice Department in cases. And in fact, the agency already has an immense institutional advantage because it gets to pre-brief those issues by writing the decision. And also, given administrative law waiver doctrines that have risen up, it gets a preview of all of those who object to the rule as well and gets to write the reasons in light of those comments and objections that have been filed or evidence that's come out in the adjudicative process. So, and my other objection to Skidmore is that I think it's entirely indeterminate. It's not rule-like. It would produce whatever outcome the judges who are applying it would see fit to apply. So I applaud the subcommittee and Congress for, and the drafter of the legislation for proposing this solution, which I think is elegant. And the last thing I'd like to do is just offer to you a couple of second bests in case there are other ways, to skin the cat, as it were, of too much authority being given to the executive branch. Number one is it's widely acknowledged the Chevron doctrine's implied delegation rationale is a legal fiction, and it is not something that Congress actually ever adopted itself. You could more narrowly target reversal of that. Also, I agree with the major questions doctrine enunciated in Brown and Williamson and in King v. Burwell. That's also something that you could enshrine even if you didn't go as far as this legislation. And the last second best I offered for you was to overrule Brand X and allow that in situations where the courts get to a question first, the agencies should be bound. They shouldn't be able to override the judicial decisions. That's turning the separation of powers on its head. So in closing, thank you for the opportunity to speak today, and the ultimate second best is to write clear statutes and to think about how the administrative agencies might try to circumvent them. And I'd urge you always to keep that in mind when you pass new legislation. Thank you.
Thank you. Mr. Wall?
Thank you, Chairman Marino, Ranking Member Johnson, and members of the subcommittee for the opportunity to testify today. H.R. 4768, the Separation of Powers Restoration Act of 2016, is a deeply flawed and harmful bill that should not become law. My oral statement will address two basic topics: the anti-regulatory legislative context that the bill now joins, and second, the bill's numerous flaws and harmful consequences. These harms include impaired safeguards for public health, safety, the environment, financial markets, consumer rights, civil rights, and other social concerns that federal regulatory statutes address. Additional harms include reduced political accountability, even more overburdened courts, increased judicial forum shopping, greater uncertainty for regulated entities, and the waste of public resources and tax dollars. H.R. 4768 overthrows a long-standing and well-founded framework for judicial review when acknowledging a regulatory process grounded in extensive administrative records, lengthy processes of public input, and expert evaluations. That framework is ultimately carried out by officials appointed and confirmed by elected officials working under an elected president. H.R. 4768 substitutes for that system one in which the judiciary may nullify agencies' reasonable regulations because one judge or a set of judges may prefer a different reasonable regulation or outcome. H.R. 4768 permits the judiciary to ignore administrative records and expertise and to substitute its own inexpert views and limited information. In my testimony, I quoted Justice Scalia's opinion for the Supreme Court in City of Arlington, where he said a de novo review standard practiced by 13 different courts of appeals would end up applying a totality of the circumstances test, which Justice Scalia recognized not to be a test at all. He wrote that this would simply be an invitation to ad hoc judgments that would render the binding effects of agency rules unpredictable, destroy the whole stabilizing purposes of the Chevron doctrine, and result in chaos. To impose this kind of judicial fiat seems especially odd coming from members of Congress who have repeatedly condemned supposed judicial overreach and who constantly point out that the judiciary is unelected. It seems that the bill's supporters are so intent on overturning our system for protecting the public through regulation that they are willing to empower a federal judiciary that they have long denounced, even though Congress has the constitutional authority to change regulatory statutes or to alter or reject individual regulations any time it wishes. But Congress does not do that because the public won't support it. First, I would like to place H.R. 4768 in a broader legislative context. Since the start of the 112th Congress, there has been a wave of legislation embodying conservative political and corporate attacks on our modern system of federal regulation and law enforcement by the executive branch. H.R. 4768 is the latest bill to join that wave. During the 112th and 113th Congresses, there were 553 House votes by the majority to weaken environmental and health safeguards. These attacks failed. Having failed despite repeated attempts to weaken substantive organic laws they do not support, anti-regulatory politicians have retreated to broad attacks on the legal infrastructure backing federal regulations. These include, for example, the REINS Act and its one-chamber legislative veto of regulations. Now, H.R. 47 joins that list. Members have promoted H.R. 4768 by condemning a runaway administrative state that is out of control. Press releases promoting the bill have blasted numerous Obama administration regulations that the members happen not to support. It is clear that support for the bill is motivated as much by opposition to federal safeguards as it is by the tug of war over separations of power between the branches. Next, I would like to address some of the numerous harmful consequences the bill will produce. First, agencies will issue fewer regulations to carry out federal laws and protect Americans. Many more congressional deadlines will be missed. I expect that is precisely what some opposed to regulation hope will happen. Second, agencies will resort to simply repeating ambiguous and unclear statutory language verbatim in regulations. Third, for the same reasons, regulations will contain far fewer details to assist state and local regulators with implementation. Fourth, uneven application of national laws would adversely impact the certainty with which businesses could operate across the country. Justice Scalia's regulatory chaos would ensue. Agencies also would find it more difficult to adopt deregulatory rules that would be considered reasonable under today's Chevron test. In my experience, it is true that starkly deregulatory rulemakings in prior administrations have foundered more often at the first step of Chevron. That would continue to be the case were H.R. 4768 to become law. One suspects, therefore, that political and corporate opponents of regulation and proponents of deregulation have made a calculation that the bill would have disproportionate adverse impacts on regulations rather than deregulation. That is almost certainly true and is the central reason why the bill should not become law. For all these reasons, I urge members of the subcommittee to oppose this legislation. Thank you.
Thank you. Professor Levin.
Chairman Marino, Ranking Member Johnson, and members of the subcommittee, thank you for the privilege of testifying at this hearing. My basic message today is to urge the subcommittee to be cautious about trying to legislate on the challenging and subtle topic of the manner in which courts should review agency interpretations of statutes and rules. There's never been consensus about how to analyze these issues, either before or after the Chevron decision. For generations, courts have recognized that agencies have some inherent advantages in interpreting their enabling legislation. For example, agencies are more familiar with the complexities in the field than a generalist court can be. They have the responsibility to make the entire system work, and they are accountable to the political process in a way that life-tenured judges are not. At the same time, courts have always balanced their deference with a commitment to uphold the law if the agency's interpretation is untenable or unreasonable. Now, Chevron changed the way in which courts speak about these problems, but it didn't change this state of affairs very much. The presumption that ambiguity constitutes a delegation sounds odd, but we should never forget that it doesn't exist in isolation. Courts have always found plenty of ways to work within and around the two-step formula in order to exert control over agencies. And the net results are not very different from what you see in other contexts in which other verbal formulas are used. But still, courts and lawyers and judges have been struggling with the complexities of this problem continuously since well before the APA was adopted. And you're asking for trouble if you assume that Congress can clear up these problems by adding a handful of words to Section 706. Now, one of the issues on the table today illustrates how difficult this is. Should the amendment add only the words de novo to the APA, or should it also codify the Skidmore test? Well, if you do the former, you throw out 2 centuries of tradition in which courts have found agency interpretations important to their decision-making. That is what most people would understand the words de novo to imply. On the other hand, if you do the latter, you accomplish very little because the Chevron and Skidmore tests tend to lead to about the same results, no matter what the wording of those tests seems to say. And you also will send mixed messages that would cause a great deal of confusion. You know, until I read Professor Bierman's testimony, I thought everybody in administrative law agreed that the law of deference was disorderly and inconsistent prior to Chevron, during the Skidmore era. So I seriously doubt that trying to revive that regime by adding a few vague and conclusory phrases to Section 706 would clear things up. And these days, you cannot use legislative history to cure these ambiguities. Well, where does this ill-conceived initiative to amend Section 706 come from? Well, partly it comes from a desire to shrink government. But expanding judicial power to overturn agency actions is a poor way to accomplish this, because in the long run, liberal judges can use that power to overturn conservative actions just as easily as the other way around. The initiative also stems from a belief that this amendment would recapture the original meaning of the APA, and I find that notion remarkable. For 70 years, administrative lawyers have taken it for granted that Section 706 allows courts to make their own judgments of how to decide questions of law, with or without deference. So it's startling to hear claims that all these lawyers over 3 generations have been wrong about that point in hundreds of thousands of cases. And ironically, as every member of this panel knows, Section 706 has been dramatically reinterpreted in multiple ways over the years to serve the changing needs of the administrative law system, and those changes range from the hard look doctrine to the rulemaking record principle. So this sudden absorption with original intent seems quite baffling to me. Well, finally, this initiative grows out of the imaginative theory that deference to agency interpretations of their own regulations, the so-called our deference, poses special dangers because they give agencies too much incentive to write regulations vaguely. And yet there's no evidence at all that agencies actually do act on that incentive. You know, people sometimes criticize Congress for relying too heavily on anecdotes. But nobody can say that here because the critics of our deference haven't even got an anecdote that supposedly supports their theory about its impact. And yet on the basis of this completely speculative theory, they want to throw out a doctrine that courts have found helpful for at least 3 generations or more. To me, that attack on our is not credible. In conclusion, Mr. Chairman, the courts are actively engaged in trying to answer challenging questions about the right way to reconcile the advantages of deference with the need for judicial controls, and they should be allowed to continue that process on their own, and the legislature should stay out of it. That concludes my remarks, and I'll be happy to answer any questions.
Thank you. Professor White.
Thank you. Chairman Marino, Ranking Member Johnson, Chairman Goodlatte, and other members of the subcommittee, thank you for inviting me today to testify on this crucially important bill. In the last 3 decades, Chevron deference's greatest offender was Justice Antonin Scalia. He believed that Chevron struck a proper balance between judicial decision-making under the rule of law and regulatory policy-making under constitutional principles of Republican self-government. But in the last 5 years, Justice Scalia appeared to change his mind, or at least he began to reconsider all of this. He hinted at this in opinions, and he is said to have expressed significant doubt about Chevron in private conversations. And one can surmise from Scalia's original pro-Chevron writings why he would have changed his mind. Perhaps he concluded that lower courts were not enforcing statutory limits rigorously enough. Perhaps he concluded that modern administrative agencies simply did not respect statutory limits anymore and were leveraging Chevron to negate those statutory limits. Or perhaps he looked around at his colleagues at the court and the lower courts, and seeing few or no people, none of his colleagues, willing to defend Chevron as strongly as he had, he decided it was time for the law to move in a direction that better reflects the realities of the modern administrative state and the rule of law, which differ starkly from 3 decades ago. But whatever his reasons, Congress should follow his example, not just in reforming Chevron, but in recalibrating the law with an eye not just to courts, but also to agencies and to Congress itself. As Justice Scalia recognized, this area of law affects the incentives motivating both Congress and the agencies. The APA should be amended to improve those incentives to promote better legislation and better administration. For Scalia, Chevron's most important quality related not to the courts or to the agencies, but to Congress. Specifically, he believed that the law needed to set a stable, predictable principle for Congress to have in mind as it drafted, enacted, and amended federal statutes. Indeed, Chevron is, from the beginning, rooted in a presumption about Congress, namely that Congress intended to allocate interpretive authority largely to the agencies rather than the courts. Whether that presumption was accurate or not, now is a good time for Congress to engage the issue directly. Whether it ultimately enacts the Separation of Powers Restoration Act in its current form, or amends the legislation to set other standards for judicial review, Congress needs to take the lead. Perhaps the most pressing constitutional debate of our time is that of the proper relationship between Congress, the courts, and the administrative state. It affects everything from financial and environmental law to regulation of the internet, and increasingly to regulatory burdens on religious liberty. Thank you for grappling with this issue, and thank you for inviting me to testify today.
Thank you. The chair now recognizes the chairman of the full committee, Chairman Goodlatte, for his 5 minutes of questioning.
Thank you very much, Mr. Chairman. Professor Levin, I'll start with you. Pick up where you left off. Congress shouldn't meddle with this jockeying that's going on between the judiciary and the regulatory bureaucracy in terms of how the courts should decide what deference to give them to how they interpret the regulators' regulations. But, I mean, this is the very core of why Justice Scalia was, after the fact, questioning the merits of a decision that he was a part of, and that is, why wouldn't Congress want to assert its legislative powers when what we're seeing more and more, we don't need anecdotal evidence, we can just look at the statistics of the rising number of regulations that are written each year, and particularly the number of regulations that come out based upon old laws written 20, 30, 40 years ago, where the bureaucracy comes back and says, you know what, we think that law is out of date now. We'll just retool our regulations. Doesn't have to go back to Congress at all for Congress to write a new law. All that has to happen is for us to rewrite this regulation. The courts will look at it, and the courts will say, well, you know what, if that's what the bureaucracy thinks that regulation means, then we should give deference to that. So I very much disagree with that assessment, and I'd be happy to give you an opportunity to respond.
Thank you for the chance to respond to that. First, I do want to dissociate myself from Mr. White's claim that Justice Scalia was rejecting Chevron. Whatever he said in private conversations, in his public pronouncements in the City of Arlington case in 2013, he strongly reaffirmed it, challenged the dissent for taking it on. In his Michigan decision shortly before his death, he
Well,
said,
let's get to the core of my
But
point, which is what's the role of the Congress
Right.
if the regulatory bureaucracy never has to come back here when they see a need for a change in the law, they just change it themselves?
Well, Mr. Chairman, as you may know, I've not been a fan of the committee's regulatory reform efforts.
I don't care whether you're a fan or not.
But what I'm
Respond to
saying
my
is,
question.
even because Congress can't effectively deal with the scope of review in 2 or 3 words because it creates enormous complexities. It's just a few words. There'll be endless debates about what it means. I'm not saying it's beyond your province. I'm just saying you can't
So
effectively do it.
What do we do when a regulatory bureaucracy says, you know what, we're going to reinterpret this decades-old law and write new regulations because we think those are more pertinent to the situation
I
we're
think you should
confronting
rewrite
today?
the laws to say what you want them to mean.
Sure, but that's this Congress compared to a Congress of 40 years ago. If we can't get it back here and they can bypass the Congress by writing regulations that they want to write, and for us to change that, we have to have it pass through the House, have to have it pass through the Senate where they have archaic rules requiring a 60-vote majority, and then we have to withstand a presidential veto if the president so chooses, whereas a bureaucrat, all they have to do is rewrite regulations on laws that were written long ago and in no way contemplated the new uses that they're imputing to those old laws. What do we do about that?
Well, I think you have mechanisms of oversight, but I think you almost have to recognize that when you give Congress agencies authority to act, then they exercise that authority and they have the legal right to act.
So what's
in that
wrong with
authority.
telling the courts you look at the law yourselves, don't give deference to one side or the other in the court case?
If Congress tells the agency to use discretion, the court would be defying the statute if it didn't allow the agency to use the discretion.
Well, I don't think many statutes overtly say use discretion. I think what we do is we don't fill in all the details. We expect them to do so within the black letter law that is in front of them. And when they don't do that, and then the courts look at those regulations, I think the courts are well within their authority to make their own decision rather than give deference to the bureaucracy, because you're just simply, both the courts and the Congress are then transferring power to the executive branch that we shouldn't.
Sometimes what we call deference is simply recognizing that they used legally delegated authority that the court may not second guess. And that is often considered a question of law. And if you pass a statute saying the court shall not allow the agency to use that discretion, which this statute appears to do.
Professor Duffy, would you like to jump in here?
I certainly agree that he just made a point that Jack Bierman made in his testimony, which is that a lot of times the practice is not really deference. In Chevron itself, and this is actually exactly what you said, that sometimes Congress writes a framework and expects the administrative agency to put in reasonable rules. That actually was what was happening in Chevron. And I was just looking back at my article that dealt with this some years ago. The Solicitor General appearing before the court in Chevron itself did not come up with some newfangled deference test. Instead, they began their legal argument with quoting the rulemaking power of the agency in full, which is what this Congress gave to the agency. And the basic point of my testimony, I think, and also I think Professor Bierman's testimony, is that this legislation would force the agencies to justify their authority on the basis of statutory law. And that's, I think, the core of what's at stake here. And I very much believe that Congress does have something to say about this. The entire APA, which is something that all of us law professors teach in administrative law and have taught for decades, that is Congress's view about how agencies should be structured. I think that's perfectly appropriate for a representative democracy to have the greatest deliberative body in that democracy think about how power should be allocated. So I strongly disagree with the idea that Congress shouldn't have anything to do with it. That's the very statute that I teach through a course called administrative law. So I think that your legislation is perfect to try to force the courts to go back and say what we're really looking for is to find agency authority if they have it.
Thank you. I agree. Thank you, Mr. Chairman. You're back.
Chair recognizes the ranking member, Mr. Johnson.
Thank you. Gosh, we're talking about regulatory reform, judicial deference to agency rulemaking, restoring, as you put it, Professor Duffy, restoring the traditional role of courts to determine what the law is. When has there ever been a time when there has not been judicial deference to agency rulemaking?
So is that, if that's a question to me, I think that the answer is that even today, for example, with the patent system,
Yeah, I mean,
there is no deference to the patent office's view of what the law is. And that is a good example of why the reasoning of Chevron doesn't even hold up in modern doctrine. That the patent office is highly expert. They are not even an independent agency. They're in the Department of Commerce. It's a very complicated statute that has vague words in it. And yet the courts have always, and I'm not just talking about for 20 years or 30 years, I'm talking about for over 100 years. The courts have determined the meaning of those statutory words de novo.
well, they have, well, Professor Levin, would you respond to that? Whether or not in the situation of the patent office, de novo review.
Well, I think Professor Duffy is more the expert on the patent system than me. I do know that there is a specialized court, the Federal Circuit, that passes on patent cases, and so Congress has specifically set an expert tribunal where you would expect to have more intrusive judicial review than elsewhere. But I would say generally, the norm is deference and has been throughout our history.
So when the Congress decides that it wants to clarify by statute a rule that has been interpreted and placed in effect by a federal agency, a rule that's been promulgated, and the Congress decides that it wants to clarify that area of the law by statute, it always has the ability to do so. Is that not correct?
It can revise the substantive law, if that's what your question is, and that is true. The chairman did point out that it's hard to get such a law passed, but it is within the power of Congress to do it.
And that's due to basically legislative ossification. We talk about regulatory or rulemaking ossification, but we've had legislative ossification around here for about 5 years or so. And I guess
because of the legislative ossification of the 5 years, plus the inherent nature of the constitutional system with bicameralism and presentment.
which is a good thing when it works.
All right.
If there's gridlock and it doesn't work, then we don't get anything done, and we continue to ossify our legislation, which then impacts what federal agencies would do to try to bring a rule up to modern standards and practical realities of the day. Do you contend, Professor Duffy, that federal judges are politically accountable and should undertake the construction of rulemaking with their awesome power and their permanent, their lifetime tenure?
I think that I do not contend that federal judges are politically accountable. The framers of our Constitution made the federal judiciary very independent by giving them life tenure.
So isn't it consistent then that the federal courts would, or that there would be judicial deference to agency rulemaking?
No, I don't think so. I think that the crucial question is, what does Congress want? Now, if Congress wants an agency to have a lot of power, it can give an agency rulemaking power, and that will be a lot of power. You don't need deference to understand.
Every agency has rulemaking power.
If the agency has rulemaking power, I still don't think you need deference. I think you just need to say that that the agency has power to promulgate reasonable rules.
Mr. Walke, what would your response be?
My response to much of this talk is that I think Americans are actually more concerned about the harms to the real world that will be unleashed and imposed by this bill. The press releases touting this bill identify a laundry list of regulations and safeguards that members happen not to support but don't muster the votes under the Congressional Review Act to overturn. And that's what Americans care about. I mean, Marbury versus Madison and the like is very interesting, but this bill would create more harms and impose them on Americans.
Because it would hurt the ability of our federal government to protect the health, safety, and welfare of the people.
That's correct. The supporters of the bill are touting the fact that it would overturn more regulations than are overturned today.
Thank you, and I yield back.
Chair now recognizes the gentleman from Texas, Congressman Radcliffe.
Thank you, Chairman Marino. I want to thank the witnesses for being here today. You know, the reason I drafted this legislation is because if you talk to everyday Americans, as I do, particularly small business owners, you hear a consistent message, and that's that our regulatory system is broken when we've got unelected bureaucrats taking ambiguously written laws and issuing regulations that vastly overstate their power. And, you know, I haven't found myself in agreement with Chief Justice Roberts often recently, but even he agrees with me on this issue. As the chairman pointed out, just a few years ago, he wrote, "The administrative state wields vast power and touches almost every aspect of daily life. The framers could hardly have envisioned today's vast and varied federal bureaucracy and the authority administrative agencies now hold over our economic, social, and political activities. The practice of courts deferring to agencies' expansive interpretation of their power as directed under Chevron has created a serious problem with our regulatory system, and it's one that really has eroded our constitutional systems of checks and balances. And as you'll hear me say frequently as we move through this process, this isn't a partisan issue, or at least it shouldn't be. This isn't about Republicans versus Democrats. It's about Article 1 versus Article 2. It's about respecting constitutional lanes of authority. This isn't so much about executive overreach as it is about legislative underreach. Congress is supposed to make laws, not unelected bureaucrats in the executive branch. And so I would urge my colleagues across the aisle, Republicans and Democrats, should support this as a solution to a problem that all Americans, Republicans and Democrats, want to see fixed. And Professor Duffy, I agree with you. This situation should never have occurred in the first place. The legislative history of the Administrative Procedures Act resulted in an explicit agreement amongst the lawmakers that there should be no deference on issues of law and that the reviewing courts should decide all relevant questions of law and interpret constitutional and statutory provisions. I think the legislative history here is very clear, and in drafting H.R. 4748, my goal was to restore court review of agency interpretation as intended under the Administrative Procedures Act and to restore the proper role of the judicial branch under the Constitution as enumerated in Marbury versus Madison. And I think that this bill accomplishes that, and I know that a majority of you here agree with me, at least in part. And Professor Duffy, I want to start with you. I want you to speculate with me for a minute. If the bill were to be enacted with the stylistic, technical corrections that you offer, how do you think this would impact the regulatory process? And specifically, I want to know, how do you think it would impact rulemaking, and in turn, how would the rulemaking impact litigation? Because I know Professor Levin here has indicated that he thinks that litigation would increase, whereas I think from your testimony, you agree with me that, in fact, it would be reduced. So if you'd address those for me.
Yes, I think, as I said in my written testimony, that increasingly there's an enormous amount of litigation around Chevron, which is completely collateral to the basic question of whether the agency has authority under the statutory law to do what it wants to do. So that instead of a brief focusing on that central issue, which is about what the law written by this Congress intended for the agency to do, and some of the provisions that the agency can rely on, of course, are rulemaking powers, which give the agency quite a bit of power. But instead of focusing on that central issue and focusing on the law, we have an enormous set of doctrines now about Chevron, when it does apply, when it doesn't apply, and when there's just this giant hole through it, which King v. Burwell created just last year, that says, well, if it's really important, then it doesn't apply at all. And already I've seen the litigation at the D.C. Circuit has increased on these issues. For example, in the case about the Internet, the FCC's regulation of the Internet, there's an entire collateral litigation about whether Chevron applies or not that the court will have to go through before it gets to the basic question, which I think is the central question, which is whether or not this Congress gave the requisite authority to the agency to write the rules. And so I think the legislation, I think it's great, I think it's very elegant, and it would simplify things and force courts to focus more on statutory law, which I think is a good thing.
Thank you, Professor. Professor White, I appreciated your comments about Justice Scalia and the shift there, and I will correct Professor Levin, it was more than just cocktail talk. In Perez versus Mortgage Bankers, Justice Scalia in the concurring judgment said, quote, "The problem is bad enough and perhaps insoluble if Chevron is not to be uprooted," end quote. But I wanted to ask you, Professor White, about, you referenced Professor Walker in your testimony and the fact that in his findings that 94% of rule drafters that he surveyed knew Chevron deference by name, and 90% indicated they drafted rules with Chevron in mind. And so in your opinion, how do you think rulemaking with Chevron in mind changes the ultimate outcome of the rule?
Well, administrators writing rules with an eye to Chevron understand that they have more room to play with within the scope of the statute, that they already have a thumb on their side of the scale in litigation that will ensue, that they can take more aggressive legal positions with less thorough reasoning than they might need to if they were put to a harder test on judicial review. Now, Professor Walker didn't, if I recall correctly, didn't get into the specific ramifications. He talked about the fact that there was broad awareness of Chevron at the agency, so I don't want to say too much, but it doesn't take a PhD in political science to see how the incentives are going to work under Chevron. It's what Justice Scalia recognized for better and for worse throughout his career.
Thank you. My time has expired, but Mr. Chairman, if I can just, I want to address something that Mr. Walk said, because you referred in both your written testimony and your oral testimony saying that my legislation is deeply flawed and harmful bill that should not become law, which didn't exactly hurt my feelings, but as I read on in your testimony, when you compared it to a wave of legislation attacking a modern system of federal regulation akin to the REINS Act, I know you intended that as a harsh criticism, but I got to tell you that's about as high praise and compliment as I could ask for. So while you didn't intend that as an endorsement, I appreciate it, and I'll yield back. Thank you.
Chair now recognizes the gentleman from California, Congressman Issa.
Thank you, and
Professor Duffy, I'm going to follow up because you made a good point and it got sort of cast away a little bit by Professor Levin. The Fed Circuit was set up to review, and they do review somewhat de novo, even that de novo review by the district courts, and it was because the decisions coming out of the district courts sometimes or often were going all the way to Supreme Court. So the special appellate exists only because of the importance of not clogging the Supreme Court. Isn't that true? That's basically why the Fed Circuit exists, for purposes of patents.
Well, the Federal Circuit was created for a variety of reasons that are complex, and I want to make it clear that the absence of deference long predated the Federal Circuit.
Exactly, and it's interesting, the Federal Circuit doesn't show a lot of deference toward the district court decisions, but I want to get one thing quickly in the record. Markman, which is a recent Supreme Court ruling, back in, well, not recent anymore, I've been here 15 years, it predated my congressional time, but the decision in the Markman case that, in fact, the judge was to rule on the meaning of the patent, and did not have to rely, could rely on the source documents and the record, the wrapper, if you will, and did not have to rely on any conclusion that either the patent holder or even the PTO reached. Isn't that true?
Well, the court did say that the job of determining the meaning of the patent was for the courts alone, and that certainly is true. In that particular case, they didn't have before it an agency construction of the patent, so they did not, I think, address the relationship between the courts and the agency in that case. But one would think that, at least on issues of law, that there would be, of pure law, there would be no deference.
And I want to, there's a number of cases in the FCC and their theory that they have authority that they did not have for the first 20 or so years of the Internet that suddenly they believe they have, or the Federal Trade Commission that's decided that cybersecurity over personal identifiable information, meaning hackers getting into your site, they have authority. These forms of overreach are not the same ones that we're talking about often because they're not about rulemaking, they're about seizing authority, aren't they?
Well, they do create, they do seize this authority usually through their rulemaking authority, though I guess the Federal Trade Commission might do it through a variety of other ways as well.
For all of us here on this side of the dais, would you say that there is, and this does not specifically go to this legislation, but that at the time that Congress passes a law and the first set of rules are being created, clean air, clean water, et cetera, that there is and I'll let others opine on this, there tends to be a set of rules that often resemble what Congress intended, and that it's the continued and unfettered rulemaking over generations that often create the ability for an agency to take something never intended in the law and simply create a rule because some new problem existed, a problem not envisioned in the law, but also not envisioned to be handed with that law to the regulators. Is that kind of a fair statement about the effect of time?
Well, I think the effect of time is interesting because, again, my overarching theme is that the courts and the agency should look to the Congress to figure out what kind of power Congress wanted to give the agency.
And that is a moment in time, not adjusted for the time 20 years later in which they're making a new rule, is what I was thinking.
One thing I think is interesting is some agencies have a super rulemaking power that expressly allows them to modify statutory law. So rulemaking powers exist on a continuum. And if Congress wants to give an agency broad rulemaking authority, even as some agencies have, like in certain areas the FCC has this power, in certain areas...
Or the Security Exchange Commission, there are a number.
You can give that power to the agency. So I again think that it depends on what the Congress wants.
Okay.
If Congress wants to give very broad rulemaking power, it's within the...
Okay, and I'm going to follow up just with a sort of a flash question because we're out of time. Congress has obviously not intended to have new laws created decades and decades after without a review, but Congress also often did not put in a stop on rulemaking or, in fact, a sunset on an agency if not reauthorized. Aren't those two of the elements that would not impact, if you will, Professor Levin and Walt, your statement that somehow we're all going to be hurt? because the basic concept of reauthorizing rulemaking and or reauthorizing agencies and thus their rulemaking would not be a great burden for the Congress, but ultimately might rein in this question of what is happening decades later without action. Mr. Clark?
I agree with that, Congressman Issa, very much.
So even though it's not in the bill, would you all agree that those are elements in legislative activity that we should consider when making laws, notwithstanding your disagreement on other parts?
Is the
Professor?
question, should you have a sunset provision for rules to be periodically reauthorized? That has not worked out very well.
Or in fact, on new rules to be proposed. In other words, the authority, an agency under a given law, relying on that law with no intervening activity, let's say 5 or 10 years, you must either reauthorize the act or reauthorize the continued rulemaking, for example. And my reason for it is simple. It does appear, having looked at your testimony, having looked at how Chevron is often used against ancient rulings of Congress and modern dilemmas, don't we, in fact, part of taking back our responsibility could or should be to set a limit? I pass a new law, the Affordable Care Act. You get X amount of years to write legislation, and you don't get to come back to us, or you must come back to us either for reauthorization of the act or reauthorization of rulemaking. Otherwise, the fact is, how long do we let you make law after we pass one? And I think I'm going to have to call it quits here. Any final comments?
My fear in light of recent years in Congress was that it would result in kind of a default nullification of laws and
Not nullification of laws, it'd be no new laws. Anyone else on the other side of that want to weigh in?
I just want to point out, without going deeply into it, that the sort of activity you're talking about is viewed much more skeptically applying the Skidmore factors than it has been under the Chevron factors, and that so that if a statute that was passed long ago suddenly gets radically reinterpreted, the courts tend to be skeptical about that. Whereas under Chevron, as long as this statute is ambiguous or silent on the issue, the courts would defer.
Thank you. Thank you, Mr. Chairman.
Thank you. Chair recognizes Mr. Johnson.
Mr. Chairman, I would ask that the statement of the ranking member be submitted for the record without objection.
So ordered. Gentlemen, we're going to go vote. I'm going to forego asking questions because I don't want to keep you here. I'd love to come back because I'd have you all to myself for the rest of the night, but I will not do that to you. So this concludes today's hearing. Thanks to all the witnesses for attending. With any member and all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials. For the record, the hearing is adjourned.